In this first lesson, looking at the nature and sources of the British Constitution, we're going to begin by taking an introduction to the concept of a constitution more generally, so examining the way in which a constitution can be defined, and then looking at how the Constitution of the United Kingdom is ordered in the way that it is, and examining the merits and drawbacks of such a state of legal ordering. Ultimately, we're looking at basic concepts of a constitution, as well as the unique nature of the UK constitution. Spoiler alert, the United Kingdom's constitution is very unique in comparison to a number of other states around the world. We're going to examine why, and we're going to examine the benefits and the drawbacks of that particular situation. The first question that we therefore have to ask is, what actually is a constitution? When we think about what a constitution is, essentially a constitution comprises the laws, rules, and practices by which an entity is governed. Now, we're using the word entity in this regard because a constitution need not apply to single states. A constitution may apply to all kinds of various different entities, whether that be states or potentially that could be business practices. So, for example, a company may have a constitution, the constitution of a company, which is the way in which a company is ran and ordered. But so too may states, and arguably the two most common interpretations of where we find a constitution existing is in relation to a company on the one hand and states on the other hand. Now, a constitution in the form of a state constitution also allows for the setting out of formal relationships between the various different branches of government. A constitution can also outline certain rights of citizens, and this is often described as some kind of Bill of Rights. We'll get on to the way in which our constitution in the United Kingdom actually comprises and codifies various rights towards individuals. Now, I'm going to use codified as a special term because one thing that is notably interesting about the UK constitution is the uncodified nature of it. So this brings us to the distinction and the delineation that we can derive between a codified and an uncodified constitution. This is one way in which we can class various kinds of constitutions, often in relation to states, state constitutions. So a codified constitution is simply one in which the entirety of that constitution is written down in one place. So, for example, the Constitution of the United States of America is a single document consisting of a main body, which is described as the United States Constitution, as well as its various amendments, there being a current 27 in practice. So, if I wanted to go online and order a copy of the US Constitution or find a PDF copy of the US Constitution, that would be pretty easy to do because the US Constitution is one single document that is written all in one place. On the other hand, an uncodified constitution is one that is not written down in a single place. Now, this is the case of the United Kingdom. The United Kingdom is called an uncodified constitution because there's no single document that we would outline as being the quote-unquote constitution. Now, one thing that needs to be noted is that the difference between codified and uncodified is not synonymous with the difference between written and unwritten. A codified constitution cannot be defined as a written constitution, and equally an uncodified constitution cannot be described as an unwritten constitution. And this is because when we talk about written and unwritten, we are referring to different things essentially. So an uncodified constitution may still be written down in certain parts, but the thing that it makes it different to a codified constitution is that it is not written down in one single place. As we get to looking at the sources of the UK Constitution in future lessons, we will note that there are various different sources, and some of these sources are written down. And as a result of that, you could not argue that the UK Constitution is quote-unquote unwritten. It is just not written all down in one single place, in one single document. That is one thing that needs to be noted straight away here. So what are the features of a codified constitution? If we had a codified constitution in the United Kingdom, or if we were looking at the United States Constitution, what are the features of this particular legal settlement? Well, the significant differences that exist between a codified and uncodified constitution is the case that when we think about a codified constitution, it exists as a, quote, higher body of law. What do we mean by this? Well, normally when we think about a codified constitution, a single written document, there is often a process in that written document which outlines the process for amending the constitution. And so the amendment of a constitution that is codified is often a special procedure that is different to that of a normal law that is passed by a legislature. And because it cannot be amended in a nice, easy way, we would suggest that the principles and laws and rules that are found in a codified constitution are entrenched. They are difficult to change. That is all what entrenchment means. By contrast, an uncodified constitution is very, very different in the sense that there are no higher laws. Because there is no single document that we can look to, and because there is no single process, special procedure for amendment, then that means that there is no higher law in place. So let's take an example of the US versus the United Kingdom. To change the United States Constitution, it requires a vast majority and a broad consensus among both the houses of the federal legislature, which is Congress, as well as the state legislatures, such that there's only ever been 27 amendments in the entire history of the United States. This is why we argue that the United States Constitution is entrenched, because the rules and principles therein are very difficult to change. Take, by contrast, the United Kingdom's constitution, where there are no higher laws, where there isn't this entrenchment. To simply change the United Kingdom's constitution, all you would need to do is pass a law in Parliament, which is a much easier process than that of an amendment formally proceeded through the process of the United States. So the result of this is that in the United Kingdom, we have no entrenched laws or no fundamental rules or principles. But this hasn't always been the case. We have had a situation where in history there have been codified constitutions that have existed in the past. Although the current UK constitution is not codified, it is the view that the Commonwealth constitution, the Commonwealth, which is that of England, Scotland, Wales and Northern Ireland, did have a written constitution towards the end of the First English Civil War between the years of 1645 and 1649. In 1653, the Instrument of Government was drafted, and this provided that the supreme legislative authority of the Commonwealth resided in the Lord Protector, and the Lord Protector was Oliver Cromwell. Now, the instrument can be said to have been a codified constitution since it exhibited a number of the properties of a codified constitution. So this is just a little interesting bit of history that we have written here. We don't need to, for the purposes of A-level politics, to essentially litigate in any great detail this particular period of history, but it is interesting to note that the way in which the Constitution operates today is not the way in which the Constitution has always operated in history. The Constitution that is uncodified in the United Kingdom is one that is a constantly evolving document, and I'm using the word document very loosely because, of course, since it is uncodified, it is not a single document. So given the distinction and delineation between a codified and an uncodified constitution, what I'm going to do at the end of this lesson is just outline the merits of both a codified system and an uncodified system, to be able to give you the kinds of arguments that are often cited for the strengths and weaknesses of these various different systems of government. If a constitution can only be changed by some special procedure, i.e. the principles therein are entrenched, then what this allows is for courts to strike down any laws that are not in line with said constitution. It provides a single base of justification and authority for a judiciary to cite when thinking about laws that are passed that are subordinate to the US Constitution, for example. So this is where we look at the idea of certain laws being unconstitutional. If we had, for example, the US Constitution, and we had a law that is passed by Congress that is completely contradictory to that US Constitution, there is no question about which of these two documents actually take precedent in the United States system. When we look at the US Constitution, that always takes precedent. So the secondary legislation, the legislation that is passed by Congress, would always be struck down. And that gives the courts a certain amount of power. A written constitution also allows for the greater protection of civil liberties and human rights. If a codified constitution clearly states certain rights and civil liberties that individuals in that state have, then those are protected by the very nature of the constitution as being entrenched. If, for example, a constitution entrenches the idea of freedom of speech, then a law that limits freedom of speech will be protected against by the courts, which could then strike down that law as being unconstitutional. When a situation of complex constitutional law arises, a written constitution is able to very easily outline the process to take, i.e., how to deal with complex legal and political issues. It simplifies the process quite significantly. By reference and by contrast, I say, the merits of an uncodified constitution are also various in their nature. The nature of our uncodified constitution allows it to be shaped and changed quickly, and this is a very good benefit since it allows us to address political and legal developments that take place within society. This means that our constitution in the United Kingdom is organic, whereas the US constitution is very difficult to change, and as the result of that, there have only ever been 27 amendments to it. In the United Kingdom, if some drastic societal or social change takes place, then it is very easy for our constitution to change and adjust and adapt to it. An uncodified constitution also helps to allow the judiciary to be apolitical. And we'll get to the reason why that is the case in future lessons' time when we start looking at the judiciary. Finally then, what about the nature of constitutional rights in the United Kingdom? There is some disagreement as to whether it is worth labelling some rights within the United Kingdom as quote-unquote constitutional rights, and the reason for this would be to stress their importance and to stress the importance of their protection. On the one hand, you have individuals such as Lord Stein, who has remarked that to classify a right as a constitutional right would be to strengthen its value in that the court is virtually always required to protect it. And in the case of our and Secretary of State for the Home Department, the Sims case, Lord Hoffman stated that the principles of constitutionality, little different from those which exist in countries where the power of the legislature is expressly limited by a constitutional document. So the idea here is that there may exist certain rights and principles that exist within our constitution that are so fundamental to our constitution that they could be and should be labelled in this way as to afford them the kinds of extra and special protection therein. Again, we will get to this when we look at the nature of rights in the United Kingdom and the protection of rights in the United Kingdom by the 1998 Human Rights Act, and the way in which the protection of human rights may be subject to change in recent and in potentially future years.